If you want to piss off a room full of lawyers, ask them one question. Did the OJ Simpson jury get it right? Some will say it was jury nullification. Some will say it was a failure of the prosecution. Others will argue it was the defense's masterclass in courtroom strategy. But one thing's for sure, decades later, the OJ trial is still the most divisive legal case in modern American history. Today, we're breaking down what lawyers still argue about: the glove, the jury, the race issues, the police misconduct, and whether the defense played the system or just understood it better than anyone else. Let's start with what most people remember: the glove. If it doesn't fit, you must acquit. That was Johnnie Cochran's line, and it worked. But what most people don't realize is how risky that move was. Prosecutor Christopher Darden made the call to have OJ try on the glove in open court. Cochran didn't force it. Darden walked right into that trap. The glove had been soaked in blood, frozen, and thawed several times. It had shrunk, and OJ was wearing latex gloves underneath when he tried it on. The fit wasn't great, and that visual gave the jury enough doubt. But here's the thing. Even if the glove had fit perfectly, the defense team wasn't banking their case on that. They were playing a much deeper, more complex game. The real fight in this trial wasn't just about physical evidence. It was about credibility, narrative, and distrust of the LAPD. This is where the issue of race and policing takes center stage. Mark Fuhrman, that name still echoes through law school classes and criminal defense offices. Fuhrman was one of the lead detectives on the case, and it came out during the trial that he had a long history of using racial slurs and possibly planting evidence in previous cases. When the defense team exposed that, it wasn't just about getting a detective discredited. It was about reminding the jury, made up predominantly of black jurors, that the LAPD had a real history of racism, corruption, and cover-ups. This was just 3 years after the Rodney King beating. LA was still recovering. Trust in law enforcement, especially among black residents, was non-existent. The defense knew this. They didn't have to prove OJ was innocent. They just had to make the LAPD look shady, and it worked. This is what leads us to one of the most debated concepts in the case: jury nullification. Jury nullification is when a jury returns a verdict of not guilty, even if they believe the defendant is guilty, because they think the law is unjust or the system is broken. And here's what a lot of people, including many lawyers, believe happened in the Simpson case: that the jury didn't believe OJ was innocent. They just didn't trust the LAPD. They didn't trust the process. So they refused to convict. Is that legal? Yes, juries can do that. But is it ethical? That's where the debate starts. Because here's the twist. When white juries have acquitted white defendants in civil rights cases, say in the 1960s, we call that a miscarriage of justice. But when a mostly black jury does the same in the 1990s, in a case involving police misconduct and racial context, some see it as payback. Others see it as justice in a different form. Lawyers still argue about this. Or was it a corrupt result, or was it an overdue correction? And the debate goes deeper. Did the defense manipulate the system, or did they simply use every tool available to them? Let's look at the Dream Team: Johnnie Cochran, Robert Shapiro, F. Lee Bailey, Alan Dershowitz, and a young Robert Kardashian who barely spoke but sat front row like a human credibility shield. They were aggressive, coordinated, and smart. They shifted the narrative from "Did OJ kill Nicole and Ron?" to "Can we trust the police?" From guilt to reasonable doubt. Cochran in particular was masterful at connecting legal argument with cultural pain. He didn't just talk to the jury, he spoke to their lived experience. He reminded them that the justice system had always worked differently, worse, for people who look like them. And when you watch the closing arguments, you see it. He's not giving a law school lecture. He's giving a sermon. And it hit. That leads to another legal point of debate. Was the prosecution just outlawyered, or were they overconfident? Prosecutor Marcia Clark was smart and tough, but many argue the state underestimated the defense and failed to adapt. They relied heavily on DNA evidence, which back then most jurors didn't understand, and instead of simplifying it, they made it more confusing. By contrast, the defense went for emotion, for storytelling. They knew what this trial was really about. This wasn't just a murder trial, it was a cultural event, a referendum on the LAPD, a test of whether the criminal justice system could be flipped on its head.